Indian Supreme Court has directed states and union territories to set up and operationalize online right to information portals within 3 months to ensure easy process for citizens and transparency in governance. But what is RTI? The Right to Information Act 2005 gives Indian citizens the right to access information held by public authorities, all levels of government, judiciary, as well as any non-governmental organizations that receive public funding. The objectives of the RTI Act are to empower citizens, promote transparency and accountability, contain corruption, and enhance people's participation in the democratic process. This act was enacted in order to consolidate the fundamental right in the Indian Constitution, freedom of speech. Since RTI is implicit in the right to freedom of speech and expression under Article 19 of the Indian Constitution, it is an implied fundamental right. This ruling was given by the Indian Supreme Court in Kulwal v. Jaipur Municipal Corporation case, 1986. Key provisions of the RTI Act include Section 4, which requires suo motu disclosure of information by each public authority including NGOs. Section 6 allows a person to obtain information in writing or through electronic means in English, Hindi or the official language of the area. And that's why the Supreme Court has directed states and union territories to set up online RTI portals. Section 8(1) mentions exemptions against furnishing information under RTI Act, while Section 8(2) provides for disclosure of information exempted under the Official Secrets Act, 1923 if larger public interest is served. While the RTI Act empowers Indian citizens with the right to access information held by public authorities, there are still many challenges to its effective implementation. One of the major issues is the lack of awareness and widespread adoption of the law, particularly in states where RTI applications are limited to only 150 words. This can make it difficult for those who do not have the benefit of formal education to effectively communicate their requests. Issues of the digital divide, lack of digital infrastructure, and lack of digital literacy hamper RTI progress, and even after 17 years of the Act being passed, several high courts and most district courts entertain only physical RTI applications. Furthermore, public information officers can often be uncooperative, using language like this division does not have the information or simply denying requests outright. According to the RTI Act, officers are liable to find out who is holding the information and transfer the application, but this is not always enforced. Unfortunately, the number of illegal denials of information is still high, and requesting information within the government is not always encouraged. Additionally, maintaining all datasets and putting information in public domain has become a major problem for authorities and requires a big digital push. Other issues with the RTI Act include inadequate authorities for information commissioners to enforce the law, poor record-keeping practices, and a lack of infrastructure and staff for running information commissions. Moreover, supplementary laws like the Whistleblowers Protection Act have been diluted. Attempts have also been made to amend the Act, including proposals to exclude political parties from its ambit and to remove file notings from the right to information. Is the RTI Act fulfilling its purpose? Do let us know in the comment section below. Don't forget to subscribe to our channel, Prepify, for more valuable content related to competitive exam preparation and general awareness. Until next time, keep learning and stay curious.